Morning, Your Honor. Sandy Wallach here from Mr. Condor. My client actually just texted me. He'll be in here momentarily. We have three motions that are just oral argument that I'm ready to present when the court's ready.
Okay.
If I could just get the other two, I have the motion for the speedy violation. What's the other two?
Demur, and there's a notice of final disposition invoking the interstate detainer. And I actually have extra copies printed if you'd like one.
I'll find them, guys.
Okay, and position number two, Carlton Williams.
Yes, Your Honor. Attorney Bernstein is here. He says the client's on the way, and I just saw Trooper Watts for the state who's inside the courthouse, just navigating the maze.
Okay. So you all let me know when you're ready to proceed on both matters. Court will be in recess until counsel are ready to proceed. Council, whenever you all are ready to proceed on position number one, is this your client? Or Mrs. Smith, pronounce the last name for me?
Trash.
It's, his full name, Your Honor, is Carlos Elysiak Fondor Trass. He is,
Okay.
accused in this case under Fondor.
Okay.
But
Would he
yes.
prefer for me to call him Trask or Fonder?
Trash, whichever.
Okay, all right. Good morning, Mr. Trask. Good morning. Let's see, the court calls the case of the state versus Carlos Fonder Trask, 19 CR 008604E. If you'll turn your microphones on for me, if they're not already on. Okay, I don't believe the state. And we ready to proceed for the state?
Yes, Judge.
Okay, we ready to proceed, Mr. Wallach?
I am, Your Honor.
Okay. You can proceed.
Judge, in regards to Mr. Trask, there are three motions, a demur, a notice of final disposition, which invokes the interstate agreement on detainers under OCGA 42620, and a motion to dismiss for a violation of constitutional speedy trial rights.
Okay.
In terms of the demur, the incident in this case occurred back in October of 2019. The allegation in the accusation that was filed is a charge of battery family violence. For that, Mr. Trask did intentionally cause visible bodily harm to Sasha Thomas. The allegation fails to set out the commission of the alleged offense in descriptive manner and fails to apprise Mr. Trask with sufficient specificity of what he must be prepared to meet. And I cite to State versus Thomas, 331 Georgia Appeals 220 from 2015, and Denard versus State 243 Georgia Appeals 868 from 2000. The accusation in this case is what the U.S. Supreme Court warned against in U.S. versus Russell, which is from 369 U.S. 749 from 1962. And that is, to quote, is a cryptic form of indictment which requires the defendant to go to trial with the chief issue undefined, is far from informing a defendant of the nature of the accusation against him. Such an indictment instead leaves the prosecution free to roam at large to shift its theory of criminality so as to take advantage of each passing vicissitude of the trial. And in this case, what you have is a demur that fails to allege how Mr. Trask left a visible bodily injury. Is this supposed to be a bruise, a bite, a kick, a choke? Where's the injury? Is it on her arm? Is it on her leg? Is it on her face? And essentially leaves the state open to, as testimony comes in a trial, they can then say, oh, it's this or it's this. And that doesn't let us prepare in advance. Based on that, we'd ask you to dismiss the accusation.
Your Honor, with respect to the argument on the demur, the purpose of the accusation is to place the defendant on notice of his charge, so that he may defend against it. The state routinely drafts accusations that track the language of the statute. That is what is at the minimum required by the state. And we have done that. Not only does the accusation inform the defendant of the crime of which he is charged, which is battery family violence. It informs him of when it occurred, which was October 20th of 2019. It informs him of the allegation, which is visible bodily harm caused to, and the person to whom it was caused, which is Sasha Thomas. It also goes a step further and informs him that that is the parent of the child that they share together. And that is the basis for the charge under family violence. And so it tracks the language of the statute, which is all that is required to put the defendant on notice. And so we would ask that you deny the defendant's demurrer. He knows exactly what it is that he is charged with. Furthermore, the accusation obviously has been supplemented by discovery, which tells him even further exactly what occurred on this particular day. But as far as the accusation goes, it is sufficient to put him on notice. It tracks the language of the statute, which is what is required.
Okay, these are standard accusations in battery family violence cases. I believe the accusation is sufficient, and I'll deny the demurrer. Next argument.
Hey, Judge, the next argument is the notice of final disposition under the interstate agreement on detainers. And as for this and the one after involving the constitutional speedy trial, I'm going to just give the court a brief timeline because some of this will be relevant for both. Mr. Trask was arrested and charged in a federal case April 22nd of 2019. He was charged with conspiracy to make false statements to a firearms dealer. He was released on bond that same date. On October 20th of 2019 is the allegation that's in the present case here. And he was released on bond from Fulton County on that case in 2 days later on October 22nd of 2019. On December 3rd of 2019, Mr. Trask was placed back in federal custody for a violation of his bond conditions related to the Fulton case. It was his bond conditions were modified based on the arrest in Fulton County, and then it was then alleged that he violated the modification by having contact with the victim or being near in the vicinity of the victim. And so the judge revoked his bond in federal court, and he remained in custody. After that, the victim provided an affidavit to me that was provided to the state that they did not wish to pursue charges. Mr. Trask remained in custody for his federal case, was sentenced in August of 2022, and was released from federal custody in June of 2023. In relation to the notice of final disposition, OCGA 42620 it contains the interstate agreement on detainers. And what that provides in essence is that if somebody is in custody, either in another state prison or in federal custody, that they can act to be brought to trial as opposed to having that detainer remain on them when they're in custody. The state and the court were both made aware that Mr. Trask was in federal custody as early as March 2nd of 2021. Mr. Trask had a bench warrant issued in December of, I believe it was 2019, for missing a court date. At that time, Mr. Trask had been placed back in federal custody. So in March of 2021, when I was representing Mr. Trask and made aware of that, I made the state and the court aware of that, and the bench warrant was lifted based on him having been in federal custody. Thereafter, I had numerous emails and phone calls with the state and the court in terms of resolution of the case, including a letter September 13th of 2022 to the solicitor and providing the solicitor's office with the alleged victim's affidavit indicating that she did not wish to pursue charges. We were not able to get the court to place Mr. Trask on a calendar. And on May 19th of 2023, I filed a notice of final disposition invoking OCGA 42620 on behalf of Mr. Trask and requesting that his case be resolved. Article 3A of that statute provides that a person in custody in another state or federal prison can be brought to trial within 180 days after notice to the state and court of his incarceration and request for final disposition. The notice of final disposition was provided as shown in the certificate of service to the solicitor's office, to the warden of the prison that Mr. Trask was serving his time at, as well as to the Bureau of Prisons. Mr. Trask was not scheduled for court or brought to trial The next court date that he had in this case was not until December 13th of 2023, which was a motions hearing like today, Your Honor. Because Mr. Trask was in custody and had this detainer on him, he suffered a longer incarceration in federal custody, and he was also not able to participate in programs that he would have been otherwise without that detainer. So under the interstate agreement on detainers, we'd ask that the court dismiss his charge for a violation of that provision.
Ms. Waldrop?
Yes, Judge. So in reading that particular code section, I do see that particular section 3A states first and foremost, when the person has been entered upon a term of imprisonment in a penal or correctional institution of a party state. So I think first and foremost, I haven't heard anything that states that there's a party state here, that there would have to be another party in agreement or to this agreement in order for it to be in effect. There's got to be reciprocation. There's got to be two parties in agreement on this. But further down in section 3A, it specifically states that there are certain things that must accompany any type of request that we don't have here. So the request of the prisoner shall be accompanied by a certificate of the appropriate official having custody of the prisoner, stating the term of commitment under which the prisoner is being held, the time that they've already served, the time remaining to be served on the sentence, the amount of good time earned, the time of parole eligibility of the prisoner, and any other decisions relating to the prisoner. So I don't see any of those things accompanied in this particular notice. I don't think that we even get past 3A with regard to its requirements. I see nothing about the time that he has to serve, the credit that he's been given, or any type of certificate from the agency in which he is serving this time. And so I think that given that the notice is missing the requirements specifically set forth in Article 3, subsection A, that I would ask the court to deny that particular or not grant that particular notice.
Judge, under Article 2A, it defines what state is for this statute and says that state shall mean a state of the United States of America, or a territory or possession of the United States. So it clearly includes the United States of America, which is who had possession of Mr. Trask. And
If you address the specifics, if you wouldn't mind, of what counsel for the state was just articulating to me.
right, well, that was her first point, was that
Oh, okay,
it
yeah.
was he wasn't in state custody, that he was in federal custody. So I am addressing that provision is that Article 2 specifically defines state as including the United States of America. In terms of the certificate that she mentions, just all we can do is place everybody on notice and make the request. We cannot force a warden or anybody else to provide us with a certificate. The notice that was filed provides the information of both this case as well as Mr. Trask's federal case, and provides notice to the state and the court of where Mr. Trask was being detained and what we were asking for in terms of relief. So that's we did everything that we could within our powers to try to get Mr. Trask here in Fulton County and get Fulton County to address his court and address his charge, Your Honor.
Your Honor,
No, go ahead.
just very briefly. Yes, so Article 2 defines state as the United States of America. That is correct. But Article 3, subsection A specifically states of a party state. That is what I was referencing. So a party state. The state has to be a party to this agreement. And just secondly, again, I think they've just admitted that per Article 3, subsection A, they did not comply with the requirements of that that section in terms of providing the information they were supposed to provide.
And from what I'm hearing from you is that you didn't do you disagree that you did not provide what the statute says that should be provided?
Because we don't have the ability to provide a certificate from a prison. So what we did is all that we could do to comply with the statute and to place everybody on notice.
Okay, but if the statute's not complied with, how do you get that done? I mean, if the statute has certain things that must be complied with.
Because the point of the statute is to allow a defendant who's in custody in another state, which is quote unquote, because it's much broader than just the literal states, to be brought to a different authority, jurisdiction to have his case dealt with. And we did everything that we could for that. So I can't, as I said, I don't have the authority to force a warden to provide a certificate. But what I can do is place that warden on notice, place this court on notice, and place the state on notice that, hey, we are asking for this case to be resolved, and we are asking for it specifically saying interstate detainer agreement provides for this. You know, please schedule his court. Let's get this case resolved. So we as I said, Judge, we have done everything that's within our ability.
And Your Honor, just finally, I will just point out that the statute is very clear. It says the request of the prisoner shall, not may, the request of the prisoner shall be accompanied by, and then it lists out certain things that must be, that must accompany the request. And so I would ask that you deny the notice.
Okay, I'm going to take a look at the statute and I will give you all a written opinion on that portion of it. Okay, next.
So the next one is the motion to dismiss the accusation for a violation of Mr. Trass's constitutional right to a speedy trial. As I mentioned earlier, Mr. Trass was arrested in this case October 20th of 2019. There was an accusation filed 10 days later on October 30th of 2019. We filed the motion to dismiss for the constitutional speedy violation on May 19th of 2023. As this court is likely aware, the test for a violation of a constitutional speedy trial is set out in Barco v. Wingo as a two-part test. The first part is whether the delay is presumptively prejudicial. And in this case, what we have is a 4.5-year delay. Which triggers that presumption of that first prong of being presumptively prejudicial. From there, you move to the second prong, which is 4 factors. The first factor is whether the pretrial delay was excessively long. And in this case, that weighs against the state. Uncommonly long delays have a tendency to compromise the reliability of trials in ways that neither party can prove or for that matter, identified. As a result, the weight according the other factors in the balancing test depends on large part on the length of the delay. And that's from Hayes v. State, 298 Georgia Appeals at 338 from 2009. The delay in this case is uncommonly and inordinately long, particularly in light of the offense. The investigation was clearly completed in October of 2019. The state filed its accusation within 10 days of Mr. Trass's arrest. And yet we are here in 2024 and he has not been tried. The second prong is the responsibility for the delay and whether it falls on the state or the defendant. The primary burden is on the prosecutor and the court, not a defendant, to bring a case to trial. That is Hester versus the state, 268 Georgia Appeals 94 from 2004. Overcrowded dockets, government's failure to provide for a sufficient number of judges or prosecutors or defense attorneys, neglect by the prosecution or law enforcement or mere convenience of the state or court all weigh against the state, although less heavily than delay purposely designed to sabotage a defendant's case. And that's Johnson versus the state, 313 Georgia Appeals 895-212. In other words, the burden is not on a defendant to somehow force the state or the court to try him. but it looks at all the various reasons that courts are often delayed and weighs those against the state and in this instance. The defendant in this case hadn't taken any action to stall or derail the proceeding. And contrary to that, as we just argued under the other motion, he was requesting to try to get the case resolved. We had let the court and the state know since early, at least as of 2021, his whereabouts. We had basically raised our hand and asked the state to try to resolve this. Third prong is whether the defendant timely asserted his right to speedy trial. As just said, that Mr. Trask hasn't taken any action to stall or derail the proceeding in any manner. He has let the state know where he is, and he has requested that his case be resolved. And then the last factor is prejudice as a result of the delay. And the courts have recognized that a speedy trial, the constitutional right to speedy trial, is designed to protect three interests. It's to prevent oppressive pretrial incarceration. It's to minimize anxiety and concern of the accused. And it's to limit the possibility that an accused defense will be impaired by dimming memories and the loss of exculpatory evidence. And that is from Porter, which is at 288 Georgia. Let's see if I can find that full site. I believe it's 569. In terms of impressive pretrial incarceration, Mr. Trask was in custody for a lengthy period because of his federal custody. However, as I mentioned earlier in prior argument, Mr. Trask served a longer period of federal custody and served a harsher period of federal custody because of the detainer in this case, which was his motivation in trying to get this case resolved. He certainly falls into the second area, which is anxiety and concern, as he had this case weighing over him for 4.5 years now, and weighing over him while he was in a position where it was affecting his liberty. And then lastly, in terms of the courts looking at the impairment of the defense, this one is, quote, the most serious because the inability of a defendant adequately to prepare his case skews the fairness of the entire system. And that's from Ruffin, which is 284 Georgia at 65. Once the threshold of presumptive prejudice is established, which is that initial prong, there is a presumption of prejudice that exists, and it increases in weight over time as the delay increases. The greater the pretrial delay simultaneously increases the degree of prejudice presumed and decreases the expectation that a defendant can demonstrate tangible prejudice to his ability to present a defense, which is Williams v. State 277, Georgia 598. What we have in this case is a presumption of prejudice under this last prong based on the lengthy delay. Georgia courts have held that a delay that exceeds 5 years is, in that case, was presumption of actual prejudice. That's in Grizzard, which is 301 Georgia Appeals at 617. And given the length of delay in this state, there is a strong presumption of prejudice in this case. Based on the Barker factors all weighing and some heavily against the state, we would ask the court to find that Mr. Trask's right to a constitutional speedy trial has been violated and to dismiss the case accordingly.
Counsel, I've dealt with this, your argument before. World circumstances were in effect at the time, right after your client was arrested. We were in the midst of a global pandemic at the time. There were various tolling that went on with respect to this court. Your client was in custody, which makes it even more difficult to move the case forward. In effect, this ORCA court was established to help move these cases forward, which has been done. I don't believe it was the state's fault that your client could not be moved forward in a more timely manner as far as his anxiety. I do understand that, but I'm sure that he had anxiety being in federal custody because of the alleged other crimes. As such, I will deny your motion to dismiss on those grounds. Okay? Anything further?
Nothing further today, Your Honor.
Okay, I suggest that since you have your client here, that you might want to speak with the state so we can possibly resolve this while you're here today. I do have one other issue to roll on, and I'll get that to you in a timely manner.
All right.
Okay?
Thank you, Your Honor.
All right. Good luck to you, sir. Unless there's something further, Ms. Waldrop, on this matter.
Not from the state, Judge.
Okay. Are we ready on the Williams matter?
Yes, Your Honor.
Okay.
Morning, Judge.
Good morning. How are you doing today?
Good, thank you.
And the last name is Carlton. What's the last? Is it Williams?
Yes, Judge Williams.
Okay. Is it spelled correctly on the calendar? Yes. Okay. Good morning, sir.
Good morning.
All right. We ready to proceed?
Your Honor, I've just been informed that this is gonna be a plea this morning.
Oh, okay. Very good. So you all let me know when you're ready to proceed then.
The state's ready.
We're ready for the paperwork has been sent back to the
Yeah, Ms.
state.
Bolton should have that.
Oh, do you want to keep them until after the plea?
Just maybe 5 more minutes. I'm sorry.
And this is Trooper Watts?
Yes, Your Honor.
Yeah, thank you for being here, Trooper. We appreciate it. And do you all want to come over to the microphone so that we can? Williams, if you'll raise your right hand for me, do you swear affirm the testimony you're about to give before this court, be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. Thank you, sir. Mr. Birch?
Thank you, Your Honor. This is the state of Georgia versus Carlton Williams, case number 21 CR 007526A. Pursuant to negotiation, the defense has agreed to plead guilty to count 1 DUI less safe. The conditions on that will be 12 months probation, serve 1 day in custody, credit for time served 1 day, alcohol, drug evaluation and treatment if necessary, risk reduction, 1 victim impact panel, a $700 fine, and 40 hours community service. And in exchange for that plea, the state has agreed to merge count 2 speeding into count 1, and count 3 following too closely will also merge into count 1. Does the defense stipulate venue and identification as well as the facts of this case for the purposes of the plea?
Yes,
Nothing further from the state, Your Honor.
Counsel?
yes, Judge. Mr. Williams, he has done his DUI school. I'm sorry, he has not done DUI school. He's done an alcohol evaluation. The evaluation recommended that he do DUI school and abstain from alcohol. Since this arrest, Mr. Williams has been diagnosed with stage 4 liver disease, so he has been kidney disease, so he has been forced to stop drinking. He's been clean and sober for a while, Judge. I don't think you'll have any issues with him while he's on probation, as he's going to be focusing on his health. I've told Mr. Williams if he gets to the point, he's done a few community service hours. He hasn't gotten 40 yet. If he does get to the point where it becomes difficult to perform those due to his health, I can inform the court, but as of right now, I don't think it's gotten to that point, but I just wanted to put that on the record in case we do have to come back and maybe seek some modifications.
Anything further?
No, Judge. I would ask for the affidavit. I would ask that upon completion of the terms, it convert to non-reporting.
Mr. Williams, it's my understanding that in case 21 CR 007526A, you wish to plead guilty to DUI less safe, is that correct?
Yes,
Have to answer yes or no.
yes, yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes,
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
yes,
Has anyone forced or coerced you to plead guilty?
no,
I'll accept the plea as negotiated. Mr. Williams, when you complete, I appreciate that you've done some of the terms. Very sorry to hear about your health problems. When you complete the remainder of the terms, it'll go to a non-reporting status, which means that you'll still be on probation, but you won't have to actively report, which will also save you the monthly fees, okay? If you do have some trouble getting some of the terms done, make sure that you just not fall off and not report to probation. You can let your counsel know, you can let the probation officers know that you're having some difficulty, and they're more likely to work with you than if you just go missing. You understand what I'm saying?
Right.
So we will give you where you need to report to probation today. I'll ask that you report within the next 2 weeks. We will give you that affidavit, counsel. And is there anything else?
Nothing further, Judge.
All right, good luck to you, sir.
thank you.
And we'll give him the where he needs to go to probation this morning.
Okay, great. We have it. They'll go to you.
Address on it, on the avenue.
Yes, it's gone.
Okay. In 4 months, just make sure. Don't reinstate it unless you.
Right. Let's go do that like next week.
Okay.
Ms. Walter, are we waiting on counsel or do we know?
I believe that he has spoken to his client. I'll wait for him to get back to put the offer and everything on the record, but
Okay,
I
I just
don't
wanted
believe
to.
we'll have a resolution today.
Okay, all right, thank you. So we will be in recess until, I guess, counsel returns.
Who is this next case for, Judge?
Those are the only 2 cases that that we have this morning, Ms. Carter, but the other, the first
So you're
case.
talking about the first case?
Yes,
Okay, and is his last name spelled Trask?
I believe it's TRASK.
Thank you.
Okay, I'll ask him when he comes back in, just so we have it correct, okay? Thank you. He informed you that he would not be entering into a plea?
That is correct, Judge.
Okay.
And just for the record, just to place it on the record, the state's offer to plea was 12 months to serve, credit for 365 days, balance suspended. So that was it. It was essentially a com served.
Okay.
And I offered a no-lo as well to the charge.
Would someone mind going to see if they are in the bathroom? If they are, well, maybe we'll have a man do it. Ms. Walter.
Oh, yeah, got through, we were put his book.
Or will they
No,
call?
he have to call,
Nope.
he'll have to call them and go over there and.
Okay, all right.
Give them.
Okay, go get the, outgoing department, or you'll get the affidavit.
No, I don't know. No, it's. Yeah, yeah.
They have a block party this weekend. See them there. So that's weekend.
Okay.
Where are you?
It's all right.
Yeah. Or is it just you?
That's fine. Yeah, well, you don't have any motions in your house. That'd be our- That, you know, it's gonna have traffic for it. They need that, so.
Yeah.
Let's
Right.
set it up for.
Thank you so much.
So,
Did, did you new to this one?
yeah, well, I just started in end of October.
Yeah. I think the last time.
Yeah, I used to be Jacob Stevens and Jordan Rice.
Jordan, that's all.
The dog they got here.
Ah.
And Judge, it's my understanding they weren't in
yeah.
the bathroom or anything. I don't know if you wanted to call them, call the attorney.
I take it that he left, so if he told you that he wasn't gonna take your offer, I assume that he's not, so. I think that completes everything. Is that right for today, Ms. Waldrop?
Yes, Judge, those
All
were
right.
the only two cases.
All right, y'all have a good rest of your day.
Judge, as far as Mr. Williams reporting, so he needs to call probation in 2 weeks as opposed to them calling him?
Right, they're not gonna call him. He needs to call them, and I said within the next 2 weeks or so, to make sure that we have the paperwork and that they're ready for him. But as soon as he calls, they will instruct him on what he needs to do.
Does anyone have a good email address? Because calling probation, it doesn't work
He
a
can
lot of
always
times.
report, it's right across the street.
What's that?
He can always go over there, it's right across the street.
Well, this just says, is there a certain date that he needs to report? 2 weeks from today, is there a certain time?
No, it's up, I give people up to 2 weeks. I have not had any problems with anyone
Uh-huh.
coming back to me, to say that they've had problems with probation. I give them that time because, the probation department, as you know, is backed up, so, but once he either calls or gets in touch with them, I haven't had any problems with that. You let me know if there are
So
some.
he can call anytime between now and 2 weeks, okay?
Yes,
Well, it takes a couple days for him to process
Yeah.
it. So I'll give
I
him,
wouldn't wait 2 weeks, because it can take a little while on the phone.